appeal in the matter of Bilta Ltd and others and SVS Securities PLC and others.
Yes, Mr. Scory.
My lords, my lady, I appeal with Mr. Emmett, King's Counsel, on behalf of TFS in the Section 213 appeal.
Yes.
Mr. Parker, King's Counsel, and Mr. Westwood appeal for claimant companies and liquidators on the 1032 and costs appeal.
Yes.
Can I raise three issues of housekeeping at the end?
Yes.
The first is the order in which the parties are going to address.
Yes, we've seen your email, or Mr. Emmett's email, I think it was, and that's fine. But have you agreed a timetable as well as a running order?
We anticipate that we will finish the 213 and 1032 today,
right,
with then costs tomorrow. The aim being finished by lunchtime, we hope.
Right, all right, good.
That's acceptable.
Yes.
The second issue, my lord, is that the liquidators have provided to the court a slight correction to one paragraph in their skeleton.
Yes.
On the Kellard case. We don't object to that.
Yeah.
The court has that. There's one point I wish to correct, if I may, very briefly, on one of the skeletons on the 1032 point. It is at core, tab 6, page 46.
Page?
46.
46.
Tab 6, page 46.
Yes.
At paragraph 3,
yes.
Your Lordship and my lady will see, first sentence, that the judge held claims could have been discovered. There's a slight danger there where we believed our own propaganda. That was our submission. The actual finding by the judge was that the liquidators hadn't proved their case. Yeah. It's the same point. The punchline is the same. I wanted to correct that reference there. The third point, my lord, is that the court will be conscious that the settlement agreement is confidential.
Yes.
Before the judge below, it was anticipated that any reference to its contents and the detail would be in camera if anybody bar the parties was in court. That didn't happen. We didn't need to go into in camera. I'm conscious, although there's nobody else apart from the parties in court today bar the live streaming, if we need to go into the detail, then I would ask the court to be sensitive to that confidentiality. Yeah. And maybe go into confidentiality.
Well, I've got a pause button on the live stream, so it needs to be paused.
It may be that all that's ultimately relevant is the percentage, and the court is aware of that. Yes. And there needn't be any reference to the figure.
Yes.
So one hopes it can be dealt with that.
Indeed.
Well, we have the figures anyway.
Oh, yes.
We do.
You know, yes. Precisely, my lord. So those were the only housekeeping matters.
Right. Well, you can take it that we've read the judge's two judgments and the skeleton arguments.
I'm grateful, my lord. Could I then open on the 213 appeal?
Just before you do, I'd like to ask a question, please. What was the judge asked to decide on section 213? Was he simply asked to decide whether section 213 extends beyond those with a managerial or controlling interest in the insolvent company? Or was he asked to evaluate the particular facts? Because he made no factual findings. No. He doesn't even recite what you now tell us are the assumed or agreed facts. So is it that simple, straightforward question of law that he was asked to decide?
He was asked to assume that the facts, in terms of what we TFS had done, were as pleaded. Indeed, in terms of what we did in terms of the service, there's no dispute. The dispute was as to our knowledge of the wrongdoing of the claimant companies. And therefore the judge was asked to take as common ground that which we did, namely acting as a name-passing broker, and then apply the legal test. Was that sufficient to constitute being a party to the carrying on of the claimant company's business?
So he was asked to evaluate the facts, was he? Because I don't think he did.
On that issue, the judgment doesn't go into the facts. The judge didn't evaluate the facts because he wasn't, as it were, in a position to make findings on those facts. What it doesn't come across from the judgment is, of course, that the judge was intimately conscious of what the facts were about what my client did, because those had all been investigated for the purposes of the limitation defence, namely what my client did, what was known to the liquidator and when, for the purposes of the Section 32 issue. So that, as it were, it may not have been expressly stated, but there was no doubt in my submission to to those in the court and the judge as to what was being addressed, albeit that wasn't stated in express terms in the judgment.
I may be being too pedantic by 3/4, but if one uses the words of section 213, was it accepted that the business was being carried out with intent to defraud? Was he ruling on that basis?
No, it was accepted that the business in the situation of Inline and Nathaniel was a fraudulent business.
Those two businesses were being carried out with intent to defraud.
My lord, yes.
So was the dispute, for the purposes of the section, simply whether TFS were parties, or was the dispute as to whether they were knowing parties?
If one looks at the judgment,
Yes.
at tab 17, and one turns to page 176, where the discussion on 213 begins. One then goes over the page to paragraph 73. There, the judge below sets out the three issues. And your lordship will see on the first point, in answer to the question, it's noted that we conceded that on the evidence presented that the claimant companies had been fraudulent, and that was conceded before the hearing.
Yeah, well, it's his subpoint 2 that was concerning me.
Oh, yes.
It looked as though he was being asked simply to decide whether section 213 is intended to apply only to persons exercising management or control, to which he answered no.
No. There's also, I'll come back to this later, a slight gloss on the language used by the judge, namely participated in, which is how the issue is framed, where the issue is being a party to the carrying on. But although it's framed in that way, it was approached by the parties on the basis, given what TFS did, and there's no doubt about that, namely acting as a broker, introducing the parties, wasn't itself a trader, but was involved, as one would expect of the broker, in communicating volumes required, prices, etc. Whether that action was constituted being a party. In terms of the issue of knowledge, the third point that my lord asked, for the purposes of the settlement, there was as it were, the contingent concession on that point. We would assume there was knowledge. And of course, in this case, the issue between the parties is not that at all times my clients were knowing parties. This is an issue where in 2009 there were transactions conducted by my clients in March, April, May, where it wasn't said we had knowledge of anything, but that knowledge dawned, it was alleged, dawned onwards over 29th of May onwards, so in June, July and August. So that's where the attack was. And one of the points I'm going to make is that when there's knowledge, it's said that 213 is triggered. When we're simply acting as a broker in an earlier period with no knowledge, can it really be said that I'm a party to somebody else's business?
Well, that's what I was about to ask you. Because certainly on one view, just sticking to the words of the statute, whether or not you are a party could be influenced by, or that decision could be influenced by the fact of whether you were knowing.
Depending on the facts, my lord, in the sense that if one knows what one is doing,
Correct. That's what I'm...
and decides, as it were, to act in concert to that end, and quite possibly, indeed, I'll come on to it later, but the Bank of India case, where one knowingly is providing banking services to give rise to a smoke screen, and one is not just providing banking services, one is, as it were, participating in the fraud and acting in concert with the fraudster. Contrast that with the proposition that merely engaging in a transaction is not necessarily being a party carrying on of the business. And to be clear, it was never doubted that my clients had and continue to have an entirely legitimate business as a very well-known broking firm, and they provided those services to Inline and Nathaniel, as they did to many other parties in the market. And that was, as it were, standard services, they were provided before, during and after. The knowledge element, in my submission, makes no difference to the qualitative label to be attached to what they did for the purposes of being a party to the carrying on of the business. But also it may say, well, they were knowingly participating in being a broker to a transaction connected to fraud. That may be that they were therefore a party to a state of affairs which led to a fraudulent transaction. In my submission, that doesn't mean they were party to the carrying on of Inline and Nathaniel's business.
I don't see that in your grounds of appeal. Your grounds of appeal, I'm looking at page 84 of the court one, tab 8. At any rate, at first blush, all concentrate on the interpretation of section 213. They don't say, well, if it does go beyond persons exercising management or control, we, TFS, aren't caught within it. And I don't see that in your grounds of appeal, in your assertion argument.
Well, I was maybe, as it were, tempted by the question from my
I may have led you astray.
Stuart-Smith, but yes, that is my approach, and I do say that the ambit, scope and purpose of 213 and the language of being party to the carrying on of a business does posit the need for there to be some managerial or supervisory control.
I understand that.
And I do say that. I also say, however, that the people in that capacity don't need to have the formal title position of a director, nor a shadow director, but they need to be somehow responsible for the decision to carry on that business in a particular way. Yeah. And simply providing services we did, in my submission, can't be categorised in that way. And therefore we are qualitatively different from, for example, the Bank of India case, where such was the involvement of the decision to provide those banking services out of the norm, that one can possibly say that one was then a party to the carrying on of that fraudulent business of BCCI. So I'm not seeking to expand those grounds of appeal, my lord, beyond what they are. And I'll come on in a moment to deal with the facts, and I hope I can help in clarifying what they are. But again, there's no dispute between the parties as to what this court should assume for those purposes. I hope the court, from the skeleton, has an understanding of how these issues arose, although they're rather lengthy. Proceedings beginning in 09, the difference in Inline and Nathaniel arises from the different point of time at which they had a corporate demise and were therefore resuscitated. And the court will appreciate that in order for me to resist the claims fully, I need to succeed on the 213 point, but also hold the judgment below on the 1032 point.
Yes.
Because there's a complete overlap between the 2013 claim and the dishonest assistance claim by the companies on the facts. There's no different conduct pointed to at all. And I'll come back to that when I make my submissions on why 213 should not simply be an accessory liability, because it's all the facts that are relied upon for the dishonest assistance claim, which are prayed in aid of the 213 claim. There's nothing new, as it were, between the two. I've taken the court to paragraph 73 of the judgment below at page 176, where the judge identified the three issues regarding 213. Just to pick up.
Well, might I just seek to bring a bit of clarity by saying what we understood the appeal to be on the basis of Malone Friend's grounds of appeal. I'm concerned Malone Friend is going to engage in some sort of evaluation of the factual evidence, which is not what we understood this appeal was to be about. From the grounds of appeal, we understood the appeal to relate to the question, looking at page 84, the question that the judge posed at paragraph 3, and then paragraph 5, saying that the judge's answer was wrong for the reasons that my learned friend there sets out.
Yeah.
Now, all those reasons are simply points of law on the interpretation of section 213 on the basic question as to whether or not it is necessary for a party to exercise management control of the company's business, as the judge said, paragraph 3, directors, shadow directors and the like, or whether the provision extends to those who assisted or contributed to breaches of duty. So it's an either or, based on the interpretation of section 213. There's no question that there's a grey area that requires an evaluation of the factual evidence, which is why the judge never, there is no evaluation of the factual evidence in the judgment, precisely because my learned friend's point on section 213 was limited to the point in the David Foxton article that 213 requires management or control of the fraudulent business, and the judge held that it did not, and therefore liability on the part of the defendant followed.
Yeah.
So really, the only question we're being asked is does 213 only apply in the event that they have exercise management or control, full stop? And if we say to that question, yes, then the appeal succeeds. If we say no, fails.
Yes, but as a point of law.
So we needn't worry about it.
Correct. Either the judge is right or the judge is wrong. If David Foxton is right as to the interpretation or what he suggested, then they succeed and we lose. But if David Foxton is wrong and the interpretation put upon the section by Mr. Justice Neuberger is correct, then we win. The court isn't asked to evaluate whether or not what TFSS did somehow falls within management of the fraudulent business.
Well, I'm bound to say, speaking for myself, that was my understanding of the appeal.
To be clear, my lord, management and control is a very easy thing to phrase to say. One often thinks of directors and office holders. The debate below, the debate in the Foxton article, is not limited to those people. As stated in the grounds, quoting the judgment of the judge below, management and control of the company's business, e.g. directors, shadow directors, and the like, wasn't confined just to the office holders and those standing behind them, but also those pulling the strings and those who are said to be responsible for the carrying on of the business. Now, there's no allegation against TFS below, certainly no finding that my clients were in any way involved in the management of the claimant companies. We just provided services to them in the market. And the issue between the parties is whether that is enough, because simply providing those services cannot amount to management or control for the purpose of being a party to carrying on with the business. When one's looking at that legal question, as part of my submission was below, and I will try and advance before your lordship and my lady, that there's a qualitative element to that. What does it mean? It all depends on the facts of the case. One has the words party to the carrying on of the business. If one is trying to see whether that applies, one can possibly use a different phrase, management or control, but one needs then to determine what is the text and the content of that, and that may well require one to refer to the agreed facts. I'm not seeking to reopen the facts, but one needs to see it in situ, because if one does require some management or control and the like, i.e. beyond merely providing a service, and the facts are that I did nothing more than provide
I understand that.
And that's
that assumes you're right on the interpretation of section 213.
Oh, yes.
But if you're wrong on the interpretation of 213, then I think you're not asking us to evaluate the facts.
I don't know. Because my learned friend's case is that if I'm wrong on that, 213 is in effect accessory liability, and anybody who simply deals with a company with knowledge is called. And so those are the battle lines. So I'm not straying from
All right.
the grounds, and forgive me if I may have engendered a thought that I was doing so. It's not my intention.
Yeah.
I hope the court has received from the parties, as it were, the summary of the facts which
Yes,
we ask
indeed.
you to assume. Now,
Yeah.
in terms of what we actually did, it can be summarised quite pithily. There's further detail about the knowledge. In my submission, that's a separate issue. Actually, what we did is just simply acting as a name-passing broker. And that was what was alleged against us, and that is indeed what we did. So one then takes as given that we are a name passing broker, and that's a term of art understood by the FCA, whereby we introduce parties. One then normally just takes the commission on the value of the deals thereafter. In addition, it's true that in this case we provided slightly more than a name passing broker, in the sense that we also, as a broker, passed on details regarding volumes required and prices, etc. We never ourselves acted as a principal, in the sense that we never purchased the carbon credits ourselves. Those are always bought or sold by the claimant companies from SVS or other counterparties. So we were in the role of a broker rather than a trader. Now, in those circumstances, we say that for the purposes of 213, being a party to the carrying on of Nathaniel and Inline's businesses requires more than merely involvement in the mechanics of their business by dint of providing services to them. It's not enough just to transact with those companies. It requires one to be a party to the carrying on of their business in the sense of being responsible for its conduct or direction. And that must entail some involvement in how that business was carried on. That, in my submission, requires one to have, either directly or indirectly, some control or involvement in how that dishonest company carries on its own business. Put another way, there must be some input into the company's controlling mind, either as a director, which is an easy scenario, similarly a shadow director, but that would also encompass, in my submission, a party, as it were, pulling the strings of the individuals, or a person acting in concert with those controlling the company in carrying on the business for a fraudulent end. And one can label that, as it were, being an insider, but that label should not falsely require one to assume that they are, as it were, within the fold of the company. It should be quite separate from the company, but nevertheless in charge of what the company is doing, because they put in a duke director and they simply put in the strings. I'm going to show that was one of the amendments to the Section 102 in 1948 was meant to capture just such an individual.
Yes.
And just to echo a point made by Mr. Parker a moment ago, and to avoid any charge of plagiarism, I want to make clear that my submissions do draw heavily on the views of David Foxton in the article.
Yeah, we've all read the article.
In which case, that's a useful aid memoir as to what my submission should be at the end of the appeal. Now, because one is concerned in section 213 with the business of the company, which has been carried on with intent to defraud, one is looking to the business of Nathaniel and Inline. And that is a business in a very generic, broad sense, by which I mean it is not concerned with individual transactions. Now, it may be directed to a single transaction where, for example, in Remayston, there was simply one transaction for the purchase of the potatoes because that was all the business was doing. And similarly, in Cooper Chemicals, there was one transaction for the pre-order of indigo because that's all the company was doing and nothing else. In which case, that one transaction was the entire business. But that doesn't detract from the point that the Act requires one to look at the business as a whole. And therefore, one is not concerned with my client's role as a broker for a given number of transactions undertaken by Nathaniel and Inline. One is looking to their business as a whole, which was a scheme set up to defraud the revenue for the purposes of MTEC.
It seems to me there's an ambiguity in that submission. You accept that a single transaction could qualify. What do you say if you have a business which has honest parts of it, but there is a single transaction which is deliberately intending to defraud creditors? So you can't say it's the whole business. That's sufficient to come within the section 213 so far as the carrying on of the business is concerned, isn't it?
Not necessarily, my lord, no.
It could be.
The ratio in Cooper Chemicals would be no. If I could take, I'll
Well,
address
you've
this
got
now.
Mr. Justice Oliver's example of the used car salesman who defrauds the occasional buyer.
Yes, the point there is that that transaction may give rise to a range of liability in equity and in tort, but wouldn't necessarily trigger 213 because the business of the company is entirely legitimate. There's, as it were, a rogue deal within the business. But in terms of carrying on the business, it's entirely legitimate business.
But on the facts, on the assumed facts here, neither Nathaniel nor Inline had any legitimate business.
Maybe that's correct, and not just assumed facts, agreed facts. But in terms of that first issue, that is true, but there's no evidence at all, nor was it alleged that my clients were involved in the entirety of that business. There could be, for example, be a difference where there's an MTEC scenario with which the courts are all too familiar, where a company pops up, does 10 deals with a trader, the HMRC are alive to the issue and they disappear, and those 10 transactions, there could only be one transaction, is all that fraudster undertook for its business. That's not the case here. The evidence below is that Inline and Nathaniel had a host of transactions with other parties beyond those which were brokered by my clients. So one is looking to that broader business which is being carried on by the companies and then posing the question, to what extent am I a party to that carrying on? Because that's what the statute requires.
So you are drawing a distinction between transaction and business, and among other things, you're saying that these companies had a broader business, albeit it was fraudulent in the terms of the section, but your client was not party to that, but it overall.
But yes. If one takes up the authorities bundle, I think I should deal with this point now. And looks at the Cooper case, which is at tab 6. Tab 6 begins, my lord, at page 83.
Do you want the bit from Murray Watson, presumably?
My lord, yes, that's on page 88, between B and C.
Yeah.
And it's fair to say that that statement in Murray Watson has never been doubted. On the facts of the various cases, it's possibly been inapplicable because there was only one transaction. But the proposition has never been doubted.
No, well, it was picked up by Lord Justice Chadwick in Morphitis, if that's how you pronounce it.
Yes, which was going to go to next, but yours was correct. So I do draw that distinction. And my lady may think, well, query whether it matters if all the transactions are fraudulent. In my submission, it does, because I'm alleged to have been involved in a number of transactions, but not everything. And if one needs to look at the totality and not simply be a party to that business, but a party to the carrying on of that business as a whole, in my submission, that gives some colour to what it means to be carrying on. That posits the idea that one is involved in the direction or the decision to have such a fraudulent business, not simply its implementation by way of a specific transaction. And therefore the fact, by way of conclusion, ultimately on this point, the fact that my client brokered 1 deal, 10 deals, 20 deals, does not bring it within the fold of being party to the as it were, the antecedent decision to begin and continue a fraudulent business by inline and Nathaniel.
But if that's right, are you saying that you would have to be involved in every transaction in that scenario to be regarded as a party to the carrying on of the business?
In an extreme scenario, my lady, yes, because that is what is required by 213. There may be dishonest assistance claims vis-a-vis the transactions in issue in which I was the broker. But of course, the 213 liability initially had the effect of those involved of removing all limitation of liability, which would mean that if there was a director back in 1928 who was found to have been knowingly a party to a certain number of transactions, and the company suffered a loss as well as others, the director would lose that protection. And because there's a contribution to what has been lost, there's a question mark over whether the liability under 213 is simply in respect of those transactions, as it were, the commercial relationship engaged with the company, either deals my client undertook, or whether it would extend to the losses caused by the carrying on of the business per se, in which I wasn't involved in the other deals. And that, I would stress that this is not a matter of giving rise to, as it were, a gap where there's no remedy. There's a perfectly good remedy in dishonest assistance. One is just concerned with whether this special regime, which gives rights to liquidators, is meant to apply beyond those responsible for the conduct of the fraudulent business.
I'm struggling with this because it seems to me that it's incredibly fact sensitive, or could be incredibly fact sensitive. Say you have a business which is being carried on, which, as it turns out, is carried on with intent to defraud, and it involves a series of transactions. And you have, under the old law, a director, or on your interpretation, a director who funds the first transaction, which then provides and has no other involvement. He does it knowingly. So you could say on one hand he only takes part in one transaction, but if you look at it through a slightly different lens, he is a party to what is the intended carrying out of the business with intent to defraud creditors. So where does where does the line draw? And B, does it matter to this appeal?
But on the facts of that example, my lord, where's the line drawn? That's not something, as it were, I need to address for the appeal, because I don't deny that these are fact-sensitive questions, and there can be nuances, and indeed, in respect of the number of other parties to these Bilta proceedings, there were many, many nuances where it was said in a very tangential way that people down the transaction chain had in some way been a party to the carrying on simply by purchasing 4 steps away. It's all very fact-sensitive, but on the facts of this case, it simply said that acting as a broker in the normal way, albeit with knowledge that the other person is not lawful, means that I am a party to the carrying on of their business. Now, in an MTech scenario, there have been many cases before the court whereby a party, for Kittel purposes, is not simply doesn't simply have knowledge of the connection to fraud in terms of being in a supply chain, but the trader may well have been in the supply chain and seen what was going on and seen that there was a carousel, but carried on buying and selling the goods, and thereby facilitating the circularity to enable the fraud to happen. Now, if there's consciousness about that, then on the facts of that case, one may say, well, one may not have been involved at the very outset in the decision of the fraudster to defraud the revenue, but when the scales fall from one's eyes and one decides to continue to do that, and without one's own involvement, the fraud can't happen, then one can see one is brought within, as it were, the fold of the decision maker, once partaking in that earlier decision to defraud the revenue. So on certain facts of the case, that may happen. It's not alleged here. Because here, I'm just providing broking services.
Well, your bull point is, as I understand it, no allegation that you had management or controlling influence.
No.
And so you're just sitting tight on that, which is why you say the issue for us is it necessary to be having controlling and managerial functions for there to be liability under 213?
Yes, and
have I understood that correctly?
Your Lordship's quite right, and one sees it most vividly when we stopped transacting with Inline and Nathaniel, because on our case, the revenue came and explained the position, and we stopped. Did their business stop? No, carried on, because they bought from other people. So were we a party in terms of necessarily? No. So we were another broker, found other clients until the revenue took further steps, fully closing down.
I'm a bit concerned we're straying into the facts here. I don't think the judge has made these findings, has he?
Well, if I know if I will know that if I'm wrong, but I'm more than happy, my Lord, to posit that as a scenario whereby there would not be an example where there wouldn't be liability under 213. And all one can say is, following on from the point made by my Lord, Justice Stuart-Smith, no allegation of involvement or management, nor was it said that absent our involvement, the business couldn't be carried on. And without wishing to engage too much in the semantics, but sticking with the language of the Act, one is concerned with the carrying on of the business of the company, namely its commercial purpose and objectives, and the carrying on of that business, i.e. the carrying on of those commercial objectives. That is language which in my submission is not concerned with the mechanics of individual transactions, but the carrying on of its raison d'etre, its commercial purpose, which has been usurped. And 213 in my submission looks to those who have been party to that usurpation of the company. i.e. has one been a party to the decision to usurp the proper purpose of the company at a macro level, or has one simply been involved as a commercial entity at a micro level in engaging with that company? Therefore, one is not looking simply for someone who has dealt with the fraudulent company. It's aimed at someone knowingly being a party, i.e. an instrumental actor in the carrying on of that business. And there may be a difference between the carrying on of a business, which is caught by the Act, and the carrying out of a business, which is not caught by the Act. That may just be another way of reflecting that micro-macro distinction. As part of that submission, there's a slight danger that insiders and outsiders give the wrong impression. What one's looking for is that input, that substantive involvement in the usurpation of the aims of the company. And before I move on in more detail to the authorities, could I just briefly run through the history of 213, because in my submission that does inform how one looks at 213 now, because its genesis was very clearly limited to office holders and shadow directors. And it was in that context that the language being a party to the carrying on of the business was formulated, and one has never lost that formulation. And that history in my submission informs the meaning to be given to that phrase. Now this begins in the second bundle of authorities at tab 28.
Third bundle, I think.
Second bundle, my lord.
No, it's third in mine.
Oh,
Never mind.
forgive me.
28.
28.
Yeah. Oh, I'm sorry. Right.
Sorry, which tab?
28, my lady. Section 75 of the Companies Act 1928.
Actually, that's in my fourth bundle.
Oh. Apologise, my lord.
Yes.
Now one sees in this Act, in the first sub-paragraph, the definition of fraudulent trading framed in terms of any business of the company been carried on with intent to defraud. And that formulation has survived until today. There are 4 points to note in my submission on section 75. First, the ability to bring a claim was not limited to a liquidator, as is the position today, but could also be enjoyed by the official receiver, liquidator, or any creditor or contributor of the company. Secondly, the declaration of liability would lie against any of the directors, past or present, but not against a non-party. And therefore, there can be no doubt that this wouldn't bite on a defendant in the position of my clients. However, 75 subparagraph 5 was wide enough to capture shadow directors, i.e. those providing directions or instructions which de facto control the company. And we say this informs what one is to understand by being a party to the carrying on of the business, because it's obviously directed to those who instructed the company or directed its aims. Its management were indeed those who were party to the carrying on of the business. And that is again reflected in subparagraph 4, where those individuals, whether formerly a director or a shadow director, who had usurped the management of the company could then be disqualified. The third point to note is under subsection 1. One had to be knowingly a party to the carrying of the business in the manner aforesaid. And that's a further restriction as to the category of directors and shadow directors against whom a declaration might be made, because there could, for example, be a director who had neglected his or her duties, such that that director had no idea a fraud had been perpetrated, and there may be a program to attach to that director's neglect for other reasons, but he or she wouldn't be called by section 213, because that neglect meant they weren't actually a party, knowingly a party to the fraud. It's also clear in my submission that the phrase being a party to the carrying on of the business in the manner aforesaid, i.e. fraudulent business, was intended to give rise to a primary liability on such a defendant. What it doesn't do is give rise to a primary liability on those who carried on the business, and then a secondary liability to those who are a party to the carrying on of the business. Instead, the business is carried on by the company, the notional legal entity. Those who are party to that, namely on this act, the directors, then incur a liability if the requirements are met. So this is a dealing with primary liability. The fourth point to note is that the potential effect of a declaration was personal liability without limit for all or any of the debts of the company, as the court may direct. Now, as noted in the Foxton article, this provision is quite clearly meant to be a veil-piercing provision. It is directed against and only against those who would otherwise benefit from the corporate veil, either a director with the privilege of a separate legal entity and limited liability, or even more extreme, the shadow director, who was one step removed from controlling the company. And that's what this was intended to do. And to the extent relevant, one sees in footnote 5 of our skeleton argument the same approach taken in Irish company legislation. And there's a reference there to an article of Patrick Usher at A47, page 1020. I don't propose to take the court to it.
Yeah, I'm not sure that Mr. Usher quite supports you in that. I mean, he agrees that the origin was what you call veil stripping, but
yes,
he goes further than that.
He does, and to that extent, he departs from Mr. Foxton, as he then was, and your lordship will be unsurprised to know where my submissions lie.
Yes.
And with no disrespect to Mr. Usher, well regarded, although he's in Ireland, the analysis is, in my submission, much more sophisticated by Mr. Foxton, not least by reference to the evidence on which he relies from the Cohen report, which I'll come to in a moment. Yeah. Whilst we're still on section 75, could I draw the court's attention to subsection 3? Now that creates a criminal offence of fraudulent trading. The equivalent provision is in section 993 of the Companies Act 2006. Now that provides for a criminal liability arising from exactly the same circumstances as a civil liability.
With one exception, company doesn't have to be in the course of winding up.
My Lord, yes, there is that distinction. In terms of the action of the defendant, exactly the same, and that's my point. Because in terms of the trigger for liability, it's the same facts and matters. That, in my submission, is important, because one then looks later at the authorities dealing with the criminal sanction, which do deal, possibly slightly more detail, with the very issue before this court. There should be a read across, because it's the same test, just a different, it's a penal liability rather than a civil liability. But there is no suggestion, either here or in later iterations of the statute, that there was meant to be a divergence. On the contrary, the genesis is identical for them both. The touchstone is to say, namely, being a party to the carrying on of the company's business.
Is there any, if you're just leaving 75, is there any relevance or weight to be attached to the use of the word any in line 1? In the course of winding up, it appears that any business of the company has been carried on. It doesn't say the business. Is that?
My Lord,
I'm still niggling away at this point.
No, I'm going to come on in a moment to the Court of Appeal Authority, which makes a point that one's not concerned with transactions. Where one has a business, it may be there are different divisions of the business. And if one is concerned with those corporate aims, it may well be that Division A, under the responsibility of Directors 1 to 5, was usurped. And that, but business, different divisions, B and C, entirely lawful. One could then still apply 213 and say an element of that overall business has been usurped. 213 is triggered. It's not necessary for similarly, it's not necessary for every transaction to be fraudulent, for there to be a fraudulent business. There may well be elements of a business which are freestanding as a business and be treated as such, which have been usurped. And one wouldn't be, in that scenario, dealing with a position whereby one has a lawful business, but an errant salesman who may have lied to a customer. One is dealing with a business which the purpose of which is to engage in fraud. And that's always the focus of 213 at that high level of direction and control. If one then moves forward a whole year to 1929, and that's at the next tab, one sees section 275 in essentially the same terms, and one can see there's no substantive difference if one turns to tab 30, where we have provided a tracked changed version.
Yeah. Well, you set all this out very fully in your skeleton argument, so I think you don't need to go through every single piece of statutory material, but you need to show us the important ones.
Then going on to 101, section 101 that comes at 47 at tab 31.
Yes.
This is the change relied upon by my learned friends, where there is a broadening, they say, of the scope and purpose of what is now section 213, because it's this Act which introduces the ability to claim against non-directors by removing director and introducing any person. And one sees that at tab 32, where there's a red line version. One sees the restriction removed as applicable to directors past or present, and simply any purpose.
Yeah.
Just to be clear, even if learned friends are right as to the expansion of liability here, the expanded class is the defendants, the potential defendants. There's no change to the foundational requirement, Namely, if I'm right so far, that one needs to be substantively involved in the direction and control of the company by being a party to the carrying on of the business. There is no change to that requirement. It's still there, unaltered, from 1928. What is changed is who can be a party to that carrying on, i.e. not simply the director. So, as it were, the conduct has not altered, nor in the language used is there any secondary or accessory liability. It's still a primary liability of that individual who is a party to the carrying on of the business. And in my submission, any other person was therefore apt to encompass not only the director and the shadow director, who was also caught by subsection 5 of the 75 in the earlier Act, but also those who didn't even meet the definition of a shadow director, because they may have been astute enough to put distance between themselves. Nevertheless, they put a dupe director in. But they were still in a position whereby they could determine that the company would no longer act lawfully and would act fraudulently.
But what's the gap then between somebody who can exercise that kind of control and a shadow director?
Well, there was a perceived gap at the time. Your Lordship may rightly judge whether there is such a gap. There was a perceived gap, and I'm going to come on to the Cohen report in a moment. But there may well be somebody who may not be a shadow director, but was in, as it were, acting in concert with some errant directors in a conspiracy or otherwise, in order to usurp the business. Now, one wouldn't normally call that person a shadow director, but they would certainly be caught now by any person, because by engaging in concert with those fraudulent directors to decide to commit fraud and usurp the company, they became a party to its carrying on.
Depending upon the nature of their agreement, would depend whether they, in your language, assumed a managerial or controlling view. Because the mere fact that you act in concert with someone who is carrying on a fraudulent business, so you're close to the line here.
Your Lordship's quite right to pick me up. If one was acting in concert, merely in the sense of, I'm told by A and B that they're going to engage in transactions with pre-orders and they've got no way of fulfilling them and they'll run away with the money, and I'm the salesman who goes out and encourages the third party to pre-order and prepay, and I'm simply, as it were, giving effect to what others have decided to do. There's a difference between that and, for example, a situation in the Bank of India case where BCCI clearly undertaken a fraud and were at real danger of being found out, and they entered into arrangements with a malleable individual at the Bank of India whereby what he would do enable the smoke screen to be erected to enable the whole fraud to continue, whereby that action, acting in concert in that sense, is much more, as it were, being at the heart of keeping the fraud going and giving effect to it, rather than, as it were, a ministerial action of just engaging in one transaction.
But he's not controlling the business in any real sense.
In the Bank of India case,
Yes.
no, he's not.
Nor is he controlling the management of the business.
No. Well,
He's simply facilitating the fraud.
Well, there is a distinction between controlling, having full control, and having sufficient control such that one is culpable under 213, Now, no doubt the cry is, well, aren't we suddenly straying into factual areas?
And aren't you going dead circular as well?
Well, there may be that point of view, my lord, but I'm still stuck with the fact that there must be ultimately a qualitative element to what it means to be a party to carrying on the business. And I am at one extreme, my learned friend is at the other. But what is clear is that on that spectrum, it is not said that I had any control over the business. So without wishing, as it were, to dodge the answer, particularly given how the issue has arisen here, that's best left for another case where it could arise more concretely. And I'm going to take you to, for example, Cooper Chemicals, one sees 213 being used, where the facts may well justify it on its merits. But it's dangerous to take, as it were, a principle that is applied in all cases thereafter, irrespective of the facts. But I'll come on to that once I've just finished with 101. If I may just return back to section 101 of the 1947 Act at tab 31. One sees at tab 32 just the shift to being any persons. We're going to draw the court's attention back to page 948 and how the amendment was brought about, which is in subparagraph 1. It's where the company's business is carried on in such a manner to make the directors liable under section 275 of the 29 Act. Then any other person may be liable. So what this Act is positing, although it's not reflected in the amendment that was then put in, is that a director is liable by being a party to the carrying on of the business. Just pausing there, that's as understood in the 28 and 29 Act, namely the director controlling the company and being a party to the carrying on of the business is how that control is exercised. That's why the director is responsible, because of that control. And any person who is also a party in the same way can be liable. What is not being done here is creating a liability of one type based on one set of circumstances for a director and an accessory or secondary liability for other individuals who do not have that level of control. It's the same test, just the removal of the restriction of an office holder, which was possibly a limitation that was causing mischief. Now, the reason for that is notionally given in the Cohen report, which is at tab 40 of the bundle, beginning at page 997. And the
40, did you say?
Tab 46, forgive me, my lord, tab 46. And if one turns on to page 1014, paragraph 149, as described by Mr. Foxton, and this is in rather laconic terms, the explanation given for the removal of the restriction on directors. I just ask you to read that paragraph, please.
I don't quite understand what you're making of this recommendation, because although Mr. Foxton describes it as laconic, what it recommends is that other persons who are knowingly parties to the frauds should be liable, not to the carrying on of the business. And although Mr. Foxton goes into what you might call the trigger for this recommendation, his subsequent recitation of the evidence seems to me to show quite clearly that the Cohen committee in its treatment of the evidence went further than the original trigger And of course, we have no idea what deliberations took place in private before they came up with their recommendation.
Your Lordship's right. The only point I seek to draw from it is if one looks to the only evidence that we do have as to the motivation, it is not a broad, very wide opening up to all and any who simply were engaging commercially with the fraudulent company. The mischief in the evidence is directed to certain scenarios. I quite accept, my lord, if one then looks at the recommendation, this is ostensibly without limit.
Yeah, well, I think you need to look at the evidence that Mr. Foxton quotes in his article as well.
Yes, so I'm going to come on to that in a moment.
Yeah.
But even if we only had paragraph 149, and it was said against me, well, what this is doing is anybody who are knowingly parties to the frauds. Well, with respect, that's not what the Act does, because the Act changes only the restriction on the category of defendants.
Well, I understand that. That's why I asked you what reliance do you place on this report.
I, as it were, I'm taking the court to it to knock down the man of straw that's going to be erected later. So if the court has that point, then I'm not going to dwell on it. I'm not relying upon this positively pray and aid my case.
No,
I'm simply saying
I think Mr. Foxton does.
Well, that's in basically the evidence given, and I take your Lordship's point. The evidence that is cited is about individuals who might not be shadow directors, but are nevertheless part of the controlling mind. And the view was those should be captured. And that's helpful as far as it goes, but your Lordship's quite right. One can't join up the dots between that and what's...
Well, yes, I'm not sure that Mr. Foxton's quite right about that. If you go on to page 1041,
Yes.
where he's quoting the evidence, one of the witnesses suggests that often than not, people are directors are merely dupes, and there's brains behind the fraud. But then, when you look at the issue that Sir Lionel raised with the next two witnesses, the question he asks at the end of the quoted paragraph is, do you think it would be useful if that section were made applicable not merely to directors, but any other party who was knowingly party to carrying out the fraud?
My Lord, yes, but your Lordship's reading the second sentence not without the first, and the first gives it context. There is a restriction in the Act. Only directors, shadow directors. The mischief is somebody's taking care not to fall into that category can one nevertheless capture them. And therefore there's a shorthand being used because it undoubtedly is a shorthand because that's not on any view the statutory language.
No, I agree.
And therefore, my point here is that one can see the gist of what Sir Lionel was seeking to do. The explanation given in paragraph 149 of the report, in terms of knowingly part of the carrying out of the fraud, echoes what is said in the second sentence. The mischief is in the first. Query what assistance one can gain from it. Possibly very little.
But this is very elegant, but you are assuming or asking us to assume that going back to the 1928 Act, being a party means having control, simply because originally it was directors and so on. It's not what it says. The only language we've got is being parties to the carrying on of the business.
Oh, yes.
And you're trying to create, it seems to me at the moment, an edifice that because it was limited to directors, therefore they could only be parties to the fraud through their management of the company and their management of the transactions and involvement. And at the moment, I don't find that compelling.
Well, then I'll give it back, my lord.
Well, no, don't go over it again. I just said, if there's something new, don't just repeat it.
I accept this is foundational. The Act, from its genesis, and every iteration thereafter, clearly addresses the carrying on of the business of the company. That's what one has to look to. Therefore, one looks to the fraudulent business and looks at the carrying on of that business that belongs to the company, nobody else. What it doesn't do is say there are those who carried on the business and those who are separately a party to it. So one looks at the business of the company, the separate legal entity. One then says, who can be liable for the losses caused by that carrying on? And the answer is those who are party to the carrying on, and those are restricted to directors and non-directors. And in my submission, that's because those are, in the normal course of events, the individuals who carry on the business. And that's expressly stated. And in my submission, that is, as it were, a firm foundation, because the Act, reading those two provisions together, is very clear that those who are a party to the carrying on of the business are the directors.
In the 1928 Act.
28 Act. And if one then moves on to the 1947 and the iteration we have today, which is any person, the qualitative input they have into the company has not changed from that in 1928.
Yeah.
And if one looks to what that is, it is the level of carrying on effected by the directors. Put another way, if it was simply being involved in a transaction where, as in this case, one simply agrees a deal to sell or buy carbon credits. If one has a company like BCCI where the directors usurp the function, they're not going to carry it out. They're not the ones who are going to deal with Mr. Samat at the Bank of India. They're not going to be the ones who deal with somebody in my client's position to effect the transaction. So they're never going to carry out the mechanics of it. They're going to direct the purposes you serve. And that's it. It's that antecedent step to which 213 is directed. Yes, those who may have been involved in giving effect to it may have tortious or equitable liability and the different provisions, but not 213, and that's fundamentally my point. And then when one gets to, and I can deal with it very briefly, when one gets to 213, although the limit, there's a limit on who can bring the claim, namely a liquidator. In terms of the building blocks of liability, namely being a party, one can see a clear line back to the original Act, and nothing has altered the nature of the trigger for liability under 213. And that applies equally to the criminal sanction that one finds in section 993 at tab 42. Now, if one then looks to those words with which we have been grappling, without repeating the points I made, in direct response to the point raised by my Lord Justice Stuart-Smith, the gateway to section 213 is identifying the business of the company itself, not the activities of individuals involved. And that's why I keep stressing that it's the business. And that, to be fair, is what a company is supposed to do. It's supposed to carry on a business. It's not envisaged that the directors, as it were, carry out the individual transactions. The directors are responsible for the direction of travel, as it were, of the business. Now, because of that, the court has my point that section 213 gives rise to a primary liability on those who have been a party. And that primary liability was initially directors, expanded to any others who had a similar role being a party to. There's no secondary liability. There are comments in two cases which appear to suggest that there's a secondary liability. In my submission, they are wrong, but I should just address that, if I may. The first is Mr. Justice Hoffman, as he then was in Augustus Barnett, in Bundle 1 at tab 9. I needn't dwell on the facts. If I could ask the court to look at page 114.
Yeah.
On the right-hand column, between the hole punches, and just read that passage down to Gerald Cooper. Now, one can make a number of points about the gloss on the statutory language, but my fundamental point is that that division between those who carry on the business and those who are party to it is not a division that one sees in any of its iterations in what is now section 213. If one looks at, turns on to tab 13, then we dip into Banker Ab, Mr. Justice Neuberger, as he then was, page 164, at letter H at the bottom of the page. There appears to be a further suggestion that there's, as it were, secondary liability. Now, in fairness to the learned judge in that case, it doesn't appear that that point, as it were, was developed an argument by either party. But my point is that it's very easy to, in the context of dishonest assistance claims in parallel with 213, to look and treat them similarly. With respect, that's wrong. There are limits to 213. And it's clear that it gives rise to primary liability, but it's not an accessory liability. And we also say that being a party to the carrying on of the business must mean taking part in the carrying on of that business. That should not be controversial. That makes sense if one is talking about a director or a controlling mind who is taking part in the carrying on of that business by, for example, directing what it's going to do. And in where 213 is triggered by usurping its proper function. We say one is not being a party to the carrying on of the business in that sense if one's simply a commercial counterparty in a given transaction.
So suppose, for instance, that there is a retailer who buys goods from a manufacturer. They are counterfeit goods. The manufacturer knows that, and he also knows that the retailer is going to pass them off as the original. You would say that the manufacturer is not party to the retailer's fraudulent business?
Well, no, because those goods were manufactured by the counterfeiter. The retailers bought them. It wasn't a party to the carrying on of the business that decided to go and make them. Now, there may be all sorts of liability on the retailer, but, and this moves on to my next point, well, I'll deal with it now. The retailer, possibly improperly, is carrying on its own business by trying to buy the goods cheaply. By dint of carrying on its own business in a given transaction, it does not thereby become a party to the carrying on of the counterparty's business. Indeed, it's a strange state of affairs whereby simply by dint of providing the services that are the core of my usual business that I'm carrying on, I thereby become a party to the fraudulent business's business and its carrying on. Because if that is right, it means that when my client acted as a broker it was carrying on its own business of being a broker, whilst at the very same time being a party to the carrying on of Nathaniel's business and Inline's nefarious business, right into the same action. If one's looking at a transactional basis, well, it is a party to the transaction, but as it was its own counterparty, it's not a party to the business of Inline and Nathaniel. You can't wear those two hats at the same time. And to do that, to make it liable just by dint of being, if being a party means one has simply engaged with the business of the fraudulent business, fraudulent company, then one is in effect transforming 213 into an accessory liability, whereby it becomes a statutory form of dishonest assistance. But it is clear, I put it that high, from the genesis of the statute, that was not its intention. Now, in terms of the purpose of 213, I have 4 points to make. Without dwelling on it, I've made the point already that the mischief which it was directed at the outset was clearly to impose liability on those who would otherwise have the benefit of the corporate veil, namely the directors of the controlling mind. And although that was expanded in 1947 to any person, the test or the trigger for liability was not altered. In my submission, it's still the controlling mind test. That's what it's seeking to do. It's still a veil-piercing function. Secondly, when one's looking at the language in 213, one cannot look at it in isolation. There are many points to make about its interaction with equitable remedies, tortious remedies. One cannot lose sight of the fact that the very same acts give rise to a criminal sanction. As in section 993 of the Companies Act, there should be a read across. Indeed, that was accepted by Mr. Justice Neuberger in Bank Arab. And in that context, it should not be controversial that one would expect clear words to create such a liability, and ambiguity will be resolved in favour of the narrow rather than the wide reading. And if one says, well, that's all good and well in the context of a criminal sanction, doesn't apply in a civil context, in my submission, it must do, because these are different liabilities based on the same test.
Although you could be criminally liable for aiding and abetting.
Oh, yes.
So in that sense, the criminal net is wider than the civil net.
My lord, that is quite right, but that's, as it were, a different basis of liability. If there's a section 993 liability, which has its genesis in the same kernel that we're dealing with here that's given rise to 213, it's the same conduct by the same individuals that gives rise to civil and criminal liability. And if one takes a narrow view of the criminal context, one can't confine it to that context. It's got to be the same test for the civil liability, because there's no justification for driving a wedge between the two. My third point is, in construing section 213, one would hope it would be interpreted to generate logical and consistent results. But to pick up on some examples given in the Foxton article, if the wide interpretation is found to be correct, then those outsiders, true outsiders, who happen to be able to appoint directors to an insolvent company would not be vicariously liable for the director's primary wrongdoing in being a party to the carrying on of the company's business for fraudulent purposes. But outsiders who were the employees in my client's position, who assisted those directors, could be liable, and their employers could have vicarious liability. Similarly, if one has a non-managing employee of the fraudulent company who was not, therefore, a party to the carrying on of the business, he or she would not be liable, even though they knew full well that the transaction was fraudulent. But a non-managing employee of a company in my client's position would, on an offence case, be liable, as would the employer on a vicarious basis. We say that can't be right. There are further implications from a wide interpretation, which in my submission should be avoided. First, and most obvious, is limitation. Because if Malone and Friend is correct as to the scope of 213, it is nothing more or less than a statutory encapsulation of dishonest assistance. It doesn't do any more, but also no less on that case. But as here, the effect of 213 is then to give the liquidator an advantage in a dishonest assistance context, which is not available to the company itself. And one can see that in some cases that could be a substantial advantage. Because the limitation period on 213 begins on the winding up of the company. But there's no limitation on the period between the acts in question and that winding up order. In theory, decades could pass before the winding up order is made. Now, there's reasonable justification for such powers to exist in terms of a generous limitation period against directors and others exercising such control. If only by analogy, there's no time limit, for example, on the liability of a trustee for fraudulent breach, for good reason. But in my submission, there's no justification for the same generosity to be afforded to those who, on the claimant's case, did not exercise control over the defendant's, over the claimant's business. And then just referring to it briefly, there's also an objection that would arise because of exorbitant jurisdiction. Now, this is again a point raised by Mr. Foxton in terms of it giving very wide scope for liability of individuals outside the jurisdiction who may never have been inside the jurisdiction, no assets here. It is truly exorbitant. And if one looks at the potential implications of that exorbitant jurisdiction, one might have thought that one would see some statutory intent behind it. Whereas if one looks at the intent, on the contrary, one sees it, the intent being rather parochial.
But a lot of the provisions of the Insolvency Act have extra territorial application. 43, for instance.
My lord, yes, they do expressly. My point is that if one looks at the parochial concern, when I say parochial, I mean concerned with the company's direction of the Act and its development thereafter, suddenly one is being asked to say, no, actually, it's far broader. It's truly a dishonest assistance statute, and it could apply extraterritorially. And that's a very different set of facts. And in my submission, that one should not go there unless there are compelling reasons. And on the contrary, my submission, one sees from the genesis, one should be focusing very much upon the fraudulent business and its control without looking to generate exorbitant accessory liability, where that can be addressed in equity. I was looking at the, if I may, at the authorities. Which I say support my position. Could I start in first bundle of authorities, tab 10, which is the Crown against Miles. Now, this was a criminal case based on section 458 of the Companies Act 85. But you have my point already that it's the same wording,
Yes.
same underlying facts. Now here the company was insolvency. It had been used as a vehicle for the sale of wholly worthless shares relating to an enterprise that just didn't exist. And some £700,000 had been taken from 400 members of the public. And the defendant, Mr. Miles, had been a salesman for that fraudulent company. And he had been found guilty after a trial of an offence under section 458, namely that he was a party to the carrying on of that company's business. Now the jury had not been directed to address its mind to the question of whether Mr. Miles had had a role in the management of the company such that he was a party to its carrying on. And it was argued that the direction was therefore wrong. And if one looks at page 120, 120,
Yeah.
if I ask the court to read the paragraph in the middle of the whole punch beginning, it was argued on behalf of the Crown.
Yes.
And then at 121, I'll come back to this in a moment, one sees a reference after the first hole punch to Crown against Grantham, and there Lord Lane's reference to the person being a party to the carrying on of the business is referred to as the person running this business, which we say gives some colour to what those words mean. And if one then goes on to page 123, that's picked up again at the first full paragraph at the top of the page.
Yeah.
So we say that is, as it were, helpful in terms of supporting a narrow rather than an overly expansive view. If I could then turn to the Crown against Grantham, that's at tab.
Sorry, just before we leave Miles, can we go back to page 122? Lord Justice Watkins summarises the appellant's arguments in 3 propositions. First one of which is, on the proper construction of the statute, some controlling or managerial function is required. And the second is, once it's conceded that not all those working for a company fall within section 458, if there is an issue, then the jury must be given clear, simple guidance. And if you go on to page 123, just the paragraph after the one you've shown us. Circumstances will vary infinitely, but we accept the force of Mr. Barnes' second proposition. They didn't accept the first proposition, which was that some controlling or managerial function is required. And then they allow the appeal because the jury didn't get the guidance that they should have done. But if the jury was simply required to answer the question, did the defendant have some controlling or managerial function, what more guidance would they have needed?
Well, if I could ask your Lordship to take those 3 paragraphs of page 123 together,
Yeah.
because what is clear is that the court in the first is adopting Lord Lane's phrase that section 458 is designed to include those who exercise a controlling or managerial function and who are therefore running the business.
Include, not
Include.
Not, it doesn't say limited to.
No, I take that point. A salesman is not a manager. And then it goes on, the point that circumstances will vary and should be given some guidance. If one then looks in the next paragraph, a complaint made that the salesman acting under orders, the words used in the summing up particularly, concurring in the trade, which is involved in the business of the company, could and may very well have had the effect of broadening the scope. That's all that's said against me. So whilst there may be gradations when one gets into, as it were, the engine room of the company as to who's running it and the qualitative nature of their control, there may be nuances that need to be addressed to the jury. But just dealing with the company is not enough. And then if one can go to tab 8, which is the Crown against Grantham, page 99. This is the potato case, where Mr. Grantham was a consultant, albeit with the ability to sign cheques on behalf of the company, who obtained the potatoes with no intention of paying for them. It's fair to say that one goes to page 104, there's a recitation of the prior provisions, but on page 105 there's a quotation from the summing up below. If I can just ask the court to read between A and B.
105 A and B. Did you say?
My lord, yes.
Thank you.
So, took an active part in carrying on the business.
Yes. There was no complaint made about that.
No.
And we submit that clearly encapsulates a narrow formulation. And then on 107 at E, one sees there the reference to made by Lord Lane running the business.
Yeah.
One looks at re-Maidstone building provisions at tab 4.
Yeah, that also says active participation.
And well, yes, there is that aspect to the case, namely with the company secretary, if one, who, as it were, didn't say, hold hard, this isn't right, and advise them to stop. If one looks at page 79, in particular at G, it wasn't simply a case where an omission was not sufficient. It's premised on the idea that there needs to be a positive act by somebody, as it were, on the inside. And indeed, there was a concession to that effect on page 80 between letters E to F.
Yeah.
So it's not just an omission case. It's still premised on the idea that one is looking to control of the company rather than simply engaging with it in the commercial world.
Do you adopt the passage at 10 at 79 F to G?
That discussion in 79 F to G, in my submission, is in the context of giving colour to the phrase party, i.e. an omission won't suffice. One has to take a positive action. And in that context, I would adopt the idea that being a party means participates in, takes part in, concurs in.
Well, you wouldn't say concurs in, I don't think, because you say that Miles goes back from concurs in because that was the trial judge's misdirection.
But this is looking to the party to and focusing on the omission. What one shouldn't do, and what was not being addressed here, is that those words are to be used in that sense. For the issue is, for the qualitative assessment, is what's alleged to have been done by the defendant. Does that amount to being a party to the carrying on of the business? It wasn't watering down the test, and one sees that because of the concession, page 80, I took your lordship to. So, yes, I don't demur from 79 F to G, but it's limited to the omission point. Could I now address head-on the cases that are said to be against me? And as a preliminary matter, the liquidators argued below with some vigour that the wider interpretation of 213 had been resolved by this court and was binding on the court below, such that I wasn't able to advance.
In Morris.
In Morris. In my submission, that is wrong, and it was correctly rejected by the judge below at judgment at paragraph 78.
Yeah.
When we initially read paragraph 2 from Learned Friend's skeleton argument before this court at tab 11 of the call bundle, page 121, the gist of that paragraph was that Bank of India is still compelling. We thought there'd been a slight rowing back from the extreme position. But again, the skeleton at paragraph 38, page 131, maintains the argument that this court is bound by the Bank of India, and it's therefore appropriate that I deal with that first. That case is at tab 19 on the bundle of authorities. This is all part of the BCCI saga. And there was no doubt that the activities of the BCCI were fraudulent and had been for a considerable period of time. The issue concerned the actions of Mr. Samet.
Sorry, which tab?
19, my lord.
Thank you.
Looking at page 345.
Thank you.
Now, at first instance, I should say that Mr. Samet had engaged in deposits and the like with BCCI in order to give the impression of liquidity where there was none. So it created a smokescreen that could not be penetrated by the auditors, knowingly, it was alleged. In that first instance, Mr. Justice Patton, as he then was held, that the Bank of India was liable. But the limited scope of the appeal is found at page 351. paragraph 16. Now, 3 issues raised. First being Mr. Sammett's dishonesty or not. Second, whether his knowledge should be attributed. And thirdly, the connection between the transactions and the fraud. Now, that may superficially look a little bit like the issue we have. In fact, that was an argument that there needed to be some moral quality and that this was just a very small element of a much larger fraud, and that wasn't enough. But what is important to note is that despite what may be perceived to be Mr. Sammett's lack of managerial input into BCCI, the issue that I'm debating now was not an issue in this case. That is clear from page 365 of this bundle. There is a quotation there from the judgment below from Mr. Justice Patton. And if I could ask you just to look at the first sentence of paragraph 121.
Yeah, you've got it at 86 of Lord Justice Mummery, or judgment report.
Oh, yes.
363.
But it wasn't in debate. And the appeal then proceeds on that basis. And indeed, the concession is repeated again at paragraph 100 on page 367.
Yeah.
Really, if one wished to be particularly critical, of course, the issue is framed as being parties to the fraudulent trading. That's not the test. We're concerned with the words of the statute. It needs to be a party to the carrying on of the business in the aforesaid manner. And whilst this case is well known,
Moss was not known for conceding points he didn't need to.
Lord no, but again, on the facts of this case, it may well be that it was thought it was a proper concession to make. And maybe it was thought that it was a better argument to deal with attribution and that Mr. Sammett's knowledge shouldn't be attributed to Bank of India. And many reasons, but the point wasn't raised. In any event, even if there's a concern that Mr. Moss may not have given much credence to this, Mr. Sammett's position in acting in effect in concert with the business, whereby the liquidity is being generated falsely in order to allow BCCI to limp on, is very much at a macro level of the existence of the fraud. It's not akin in any way to a party such as my client is simply engaged with it. So in that submission, in my submission, this case doesn't bind this court because it was conceded. I could take your lordship to the points below before Mr. Justice Patton, where likewise there was an
Well, you've shown us that bit from
there was an express concession.
Yeah.
So it's, as it were, it's all to play for. Then one moves on to the NatWest case. Mr. Justice Snowden, as he then was, deals with this point, and his lordship, tab 24, at 622, paragraph 186. With respect, wrongly concludes that Bank of India was binding upon him.
Yeah.
And if that's not right, then there's no issue further taken. There's no further discussion in this case to assist or inform this court. And whilst I'm there to deal with it, there's a reference in the next paragraph to Alpha Sim, which was an MTEC case involving section 213. And that can be dealt with very briefly without needing to take the court to it, because the issue I raise now was not debated in that case. So again, no assistance can be gain from that. So it still is open to me, my submissions, to make the point on the narrow construction. Turning then to the substance of the points of the authorities against me, my learned friend relies upon Bank Arab, and that was the first case addressed by the learned judge below. Could I first deal with the antecedent case in time, namely Cooper Chemicals, because that is also relied upon by Bank Arab. Now that's in the first bundle of authorities at tab 6. Now, just by way of background, as one can see from the head note, a company called Jimlu had loaned £150,000 to Cooper Chemicals. And as of the date for repayment in June 76, it was not going to be paid. Cooper Chemicals was insolvent because it hadn't even begun its production of indigo, had no ability to do so, just lost the money. And Jimlu agreed to defer payment until the following month, in August. In August, Cooper Chemicals took an order for a handsome amount of indigo from a customer called Harrison's and insisted upon prepayment, £125,000 worth of prepayment. And on the same day it was paid, it paid the substantial amount of that, £110,000, to Jimlu in discharge of the debt. Unsurprisingly, Cooper Chemicals never made the indigo, never provided anything to Harrison's. Harrison's applied under the Companies Act, under what is now section 213, against Jimlu and its directors. This judgment is in respect of a strikeout application brought by Jimlu, seeking to argue that the claim by the creditor disclosed no cause of action against it. Now, in terms of the case against Jimlu, if one reads the judgment of Mr. Justice Templeman, as he then was, it appears to be a case of another creditor to the company receiving discharge of a debt, where those funds are received knowing they've been obtained by fraud. Just pausing there, that has sort of concerns again about Crown against Miles and being passive, simply receiving monies and the like. If one reads the argument summarised, it's clear that Jimlu had much more involvement. One sees that at page 85. Now, could I ask the court to read the paragraph beginning, the facts alleged, between the hole punch to the end of that paragraph?
So 85?
Page
The facts
85.
alleged in the Mr. Crawford's argument?
My lord, yes.
Yeah.
Remember, Crawford is for the applicants, Harrison's. So applicants and the application, respondents and the summons to the strikeout. It's rather confusing, but this is the party making allegations against Jimlu.
Yeah, so this is the lender. The supplier of the person who...
The purchaser who pays the money for the indigo, my lord, yes.
Yes.
Now one sees there not merely the inference that Jimlu was a knowing party to the carrying on. The allegation is that Jimlu were principals, principals to the business being carried on. There's an echo there of the language in the statute. They were a party by insisting on payment. Now, if that is right, namely that Jimlu insisted on payment and said the way to go about it is to go and effect the fraud upon Harrison's, this is tantamount to saying that Jimlu was an insider, not an outsider, because it insisted on how it carried on its business. That is clear from the argument, in the last sentence at G on page 85. If one then looks at the judgment of Mr. Justice Templeman at page 87, and if one looks at E, there's a statement there by making payment, the Cooper companies defrauded Harrison, just pausing there, that's obviously right, and by accepting the payment with knowledge of all the circumstances, except the name of the defrauded customer, the respondents became parties to the fraud on Harrison's. Now, it may well be that receiving monies one knows has been obtained by fraud may give rise to accessory liability and may give rise to knowing receipt. It wouldn't make them a party to the principal fraud, but it would if they had insisted that this was how Cooper Clark obtained the money, which is what is recorded in the argument by the creditor. And therefore, that again suggests this was really an insider case. If one then looks at page 89, one sees at E and F the argument of Mr. Evans' loan submitted in the alternative. Now, one queries to what extent this argument, as it were, only arose during the hearing. It's not recorded as part of the argument at the outset. But taking literally, what was being submitted there by counsel for Jim Lew was that, taken literally, the relevant section applied only to persons with the power of management or control, i.e. not to those with informal or conspiratorial management or control. And if that is the gist of what was being submitted, it's no surprise.
Where are you reading from? Oh, yes.
Middle paragraph, by law.
Yeah, no power of management or control.
Now, if I am right in my reading of the argument at page 85 being made by Harrison's, then this very technical argument by Jim Lew on page 89 is all that will be left open to them, because the allegation was that, in effect, Jim Lew had insisted that the Cooper companies engage in fraud by seeking advance payment with no hope of producing any indigo. Therefore, one has the very colourful language at the end of the paragraph between F and G on page 89. A man who warms himself with the fire of fraud cannot complain if he is singed. Again, that may be entirely correct on the facts of that case. What that does not permit one to do is ignore the statutory language and simply convert section 213 into accessory liability for third parties. That is not what the issue was in that case.
Well, is that right? I mean, if you go back to 84, what Mr. Evans' loan is saying, that the applicants aren't alleging that the respondents have been involved directly or indirectly in any transaction earlier than the sale of the indigo. Then at H, no direct allegation that the respondents were at any time involved in the carrying on of the business of the company. So he is taking that point.
Yes, that is what Jim Lew was saying, that this wasn't alleged against them. But one sees on page 85, the retort by Harrison is, yes, it is alleged against you. I am alleging all this.
Yeah.
And that's my point. Given this is a strikeout, really the court seems to be saying, well, there's a conflict here. I've got to take what Harrison say at face value, because it's their plea. and therefore this can proceed on. I'm not going to strike it out. Now, true it is, when one sees, my lord, the point made by Mr. Evans-Lone about what is pleaded, one sees what Mr. Crawford says on page 85, between E and F, twice, there's an inference. Now, it may well be that, in argument, the point had to be made that the inference one draws from the pleading, conjecture on my part, but the inference is. But the punchline is clear of what was being said by Harrison's, and that would be sufficient to trigger 213. Then my last point on this case, one looks at page 90, and it's the last sentence of paragraph at B. If the respondents, Jimlu, know nothing of the operations of the Cooper Company, they will be safe both against Harrison's and against the liquidator. And that's all about knowledge, because, of course, absent knowledge doesn't work. But it posits the notion that if a creditor takes payment from a debtor, whether it be a commercial lender or a bank, then receipt of that money is enough to be a party to the carrying on of their business. I mean, in my estimation, that doesn't work. It needs to be something more than that. Simply carrying on one's own business, point I made earlier, doesn't mean one is party to the fraudster's business. Could I then grapple with Bank Arab at tab 13? Which is relied on very heavily against me, and given the authorship, I need to deal with carefully. The first point to note is, as with Cooper Chemicals, this was a case management decision. And here the counsel come along to ask for a preliminary issue and found himself arguing the full merits of it. Now, that may well have been an appropriate case management approach to take on the case, but it does mean that one needs to be cautious about taking as gospel, as it were, what is said here, because it clearly wasn't subject to the same scrutiny.
And the decision in the case was that the claim against Bank Arab was not bound to fail.
Nothing more than that, my lord. No. So I can take the point quite briefly there. The role of what Bank Arab did is set out at page 164 at letters D to G, just by way of summary. Again, it's part of the front. And then as part of the case management decision not to order the preliminary issue, there are 6 reasons given. If I may just very briefly go through them, because they are raised against me in terms from Leonard Friend Skeleton. The first is that the language was not limited to the person who actually directs or manages the business concerned. It's more natural reference, it is said, to people who are not employed by the company at all, but who are third parties. Now, you've got my submissions on why, with respect to the learned judge, that's not correct when one looks at the language used, both in its original form, with the limitations of directors, and in the same form thereafter, albeit as applied to any persons. Because this appears to be based on the idea there are those who carry on the business of the company and a different group who are party to the carrying on of the business. But that is absent from the taxonomy of section 213. The second point over the page, 165, is that the policy of permitting liquidators to pursue a person who actively and dishonestly assisted and or benefited from the company, etc., outweighed the policy consideration against stultifying normal business transactions. Now, there is the preliminary point, which is this appears to look at 213 as accessory liability, and it's not. And secondly, everybody agrees that fraud is a bad thing. One is not concerned with the policy, one is concerned with the terms of the statute and whether they are so expansive as to cover the liability in question. Therefore, to the extent one's concerned with policy, there is, with respect, not a detailed exposition in that single paragraph. The third point is that the provision 213 is contrasted with 212 and 214 and said that the narrow interpretation which I advance would cause the apparently wider words of section 213 to have a narrower application. Now, the point is in some ways impressionistic, and one queries the extent to which one can gain by debating it. But in any event, in my submission, it's flawed. Because the liability in section 212 applies to any person who has been, and I quote, been concerned, taken part in the promotion, formation, or management of a company. That's much wider than the narrower scope of section 213, which is not concerned with promoters or those at the outset, but those concerned with carrying on the business, i.e. the management. Therefore, 212 is indeed directed at a wider class. So that, I submit, is not a good point against me. The fourth point is a reference to the legislative history. One queries the extent to which that is truly a separate point from the second, namely the purported policy. And I've made my points on that history. I don't propose to repeat them. The fifth point is the wide interpretation is said to be consistent with early authority, particularly Gerald Cooper Chemicals. I've taken the court to that in my submission. That is not authority for a very wide interpretation at all. It may be right on its facts, but in actuality supports a narrow view of those who are caught by the ambit of section 213. And the sixth point, at 166, is a rejection of any assistance gained from the criminal cases to which I've taken the court. And the reason is that all three cases involve consideration of a defendant who was employed by or acted for a company carrying on activities which were caught by the equivalent of section 213. Now, with respect, we say that's not a valid reason to ignore those cases. If an employee or agent of a company is only liable if they exercise some managerial or controlling or substantive input into the carrying on of the business, there's no reason why that same requirement shouldn't apply to the liability of a non-director or a party in my client's position. Now, true it is in Kellard, the party who was neither an employee nor a director was an agent in the sense that he acted as a company's agent. In Re Maidstone, referred to, the defendant was a company secretary. The point there was that the company secretary was neither a director nor an employee, not an office holder, initially a scribe. The functions have expanded, but in terms of status, that doesn't accord with the point made by the judge. If one then looks at on page 167, the last paragraph in my judgment. If I could ask the court just to read that last paragraph, please.
What's the missing word in line 2 after C's? Control, something like that?
Must be control, my lord. In fact, I thought it was and I'd read it in. So I had ready to seize control without realising the control is not there. Seize control of the business concerned. That must be right. But we will see if we can find another copy elsewhere just to check that, if that's reported elsewhere. The court has read that paragraph, including the word control. In my submission, that would generate odd results. It would mean that if those controlling or those who are managing a company, namely parties that are carrying on of its business, resolve together to carry on that business for a fraudulent purpose, they may then tell an employee about that purpose, even a senior employee, and then order the employee to undertake or complete a transaction in furtherance of that fraudulent purpose. But in that scenario, the employee will not be responsible under 213. But if that employee phones up its usual broker and says, can you get me X, Y, and Z? And that broker has merely blind eye knowledge that all is not as it should be, I suspect there may be something wrong but asks no questions. And that counterparty may be liable. And that is, in my submission, an unattractive imbalance between the parties. It's not what Section 213 was intended to do.
But there is a potential distinction there between the following, simplifying, between following orders and the transactional freedom of the counterparty.
If it's limited to, as it were, a following orders defence, I accept that there's a slightly different policy there. But what if one has a senior manager, maybe not a director, but there may be a, as it were, a divisional manager.
But they may then fall within your management and control, the management and control concept, which I assume from what you've been saying relates to the business.
Yes.
In question.
Yes, no, that is quite right on this premise.
Senior employee might well have that.
Well, on this premise, it's been directed to do so. The relation is quite right. That was the point I made.
You're also assuming that when Mr. Justice Newberger says an employee who is merely carrying out orders does not fall within the section, he was right.
Yes. Yes, but on there, I would submit that he was right, because there an employee is merely carrying out orders. He's giving effect to transactions which, as a whole, constitute the business. The employee may even have been carrying on business. He was not a party to the carrying on of the business. He's carried it out. That phraseology in my submission is important in the Act because of its genesis, which was at a directorial level, carrying on of the business. So, with respect to the judge in this case, this again doesn't address the points that I have made, certainly not in a satisfactory way, and is not a basis on which one should expand 213 to, in effect, accessory liability on a broad basis. And we should say nothing more about Bank of India, because the point didn't arise, therefore no more debate. Unless I can assist further, that's what I want to say about on the authorities. And I suspect more than once the court has my submission on the extent and scope of 213.
Yes.
And those were the points on the appeal. I don't need to take the court to what was said below because nothing was said below.
All right.
I don't say that critically. That was the basis on which you proceeded before the judge.
Yes. Thank you very much. Yes, Mr. Falk.
Lords, my lady, just by way of preliminary observations, I rose a little while ago to emphasise the focus of the appeal is on this very narrow point as to whether or not reliable under 213, some management and control of the company's business is necessary. So we are dealing with the extremes of the position. Malone and Friends says that there's a spectre, there may be a spectre, but for the purpose of this appeal, we're simply concerned with the extreme of whether or not management and control of the company's business is required. It's not therefore a test of whether or not the actions kept the fraudulent business going, or whether the actions were such as without which the business could not be done. Question management or control. And the court is aware that we urge upon the court the reasoning of Mr. Justice Neuberger in the BAII case, starting with the question of the section as a matter of ordinary language. We think it is highly significant that when this issue has been addressed by the court, Mr. Justice Templeman and Mr. Justice Neuberger have both come to the conclusion that on the language of 213, management and control of the fraudulent business is not required. And we say that's a very easy means of testing what is the meaning of the ordinary language. The two judges have looked at it and come to the same conclusion. Now, we say that conclusion, as a matter of ordinary language, is clearly right. We've seen, and I'm grateful to my friend for going through the authorities so extensively, we've seen that Mr. Justice Neuberger, his response on the question of ordinary language was directed to quite what the meaning of a party is. But we've also discussed quite what carrying on the business means. And we say that it is important to bear in mind that carrying on a business is not synonymous with managing a business, not what the section says. Carrying on a business is a multifaceted activity. And as Lord Justice Stuart-Smith points out, the statement is any business. Learner Friends sought to deal with that by a suggestion that that's directed at where you have some sort of formal department or division within the business. And we say there can be no logical or policy basis for requiring that there be a formal separation of a part of the business for it to come within any part of the business. And the notion that carrying on the business is a multifaceted activity such that management and control is not required was one that we see in Mr. Justice Hoffman's judgment in the Augustus Barnett case. Just take you to it. It may be that I'm sure the court has it in mind, but just in case the particular words were not picked up on, it's at tab 9. And on page 114, and the second column, reading from the first non-indented paragraph, he says it's a necessary condition of the court's power to make an order under this section that it appears that any business of the company is being carried on with intent to defraud. Transferring the passive to the active voice. This, in my judgment, involves a finding that someone has done an act which can be described as carrying on some business of the company. A simpler reference said an act which can be described as carrying on some business of the company. No suggestion there that the act is limited and has to be in the context of management. And again, that's Mr. Justice Hoffman's response to what he considers is the ordinary meaning of the language used. And Mr. Justice Hoffman there also draws the separation that was drawn also by Mr. Justice Patton, as cited in my skeleton argument, between the carrying on of the business, any part of the business, with an intent to defraud, and being a party, knowingly being a party to that. So that obviously raises the point. And this is, again, in the Augustus Barnett case. One focuses on the requirement that the business is being conducted with intent to defraud. And then separate from that is the question of whether or not someone is a party knowing that the business is being conducted with an intent to defraud. So the intent to defraud, we would suggest, does put a focus upon the management, but that is separate from the requirement that the particular defendant simply has to know that the business is being conducted with intent to defraud, which is divorced from any notion of management.
Well, it's a bit more than simply knowing, isn't it? It's got to be party to it, whatever that
You've got the party number, yes. Yeah. Now, my learned friend uses in his skeleton argument what he sees as the contrast with the notion of being a party to a contract. We say that illustrates the strength of our submission. There's one aspect, an important aspect of carrying on business of the fraudulent company is that it will carry on business by entering into contracts. The counterparty to those contracts is obviously a party to the contracts, is therefore a party to one aspect of the fraudulent company's carrying on of its business. The party is carrying on its own business, as my learned friend points out, but is also a party to the fraudulent company's carrying on of its business. And they're not inconsistent. So we say that if one actually seeks to pass the language of section 213, it clearly supports the construction that Mr. Justice Neuberger and Mr. Justice Templeman have put upon it. Now we go on to say that if there had been any doubt on the matter, it is clear from a comparison of section 213 with other sections of the Insolvency Act that the broad construction is the correct construction. Obviously, it's a principle of statutory interpretation that one looks at the Act as a whole. And we, as did Mr. Justice Neuberger, we highlighted in particular section 212. We've also cited section 133. When Parliament wants to make reference to a requirement that a person be involved in management, it is well able to do so. Then, moving on to Mr. Justice Neuberger's reliance on policy, which was his second reason. He puts it in, I might say, negative terms. He said there's no good policy reason to restrict section 213 to those with the management or control of the company, as one's dealing with a provision that requires dishonesty. It's the dishonesty that is attracting the liability. We say there's no reason of policy why one should be saying that the dishonest people who are party to the fraudulent trading are not liable, and it's restricted to management or control. The genesis of the section clearly was directed at management or control because it was limited to directors. But it would have been the simplest thing simply to have expressed the whole provision in respect of management, which would mean that had there been an extension beyond management, the wording would have had to be changed. But the wording was sufficiently broad, once it's divorced from liability being restricted to directors, to encompass people who weren't engaged in management or control. And as the court has seen, the policy behind section 213 was considered by the Court of Appeal in Bank of India and Morris. We had that at tab 19. And if we go to tab 19, there's a very full discussion. Go to pages 366.
I don't suppose you're going to finish this in a couple of minutes, are you, Mr. Parker?
No, don't look.
Shall we resume again at 2 o'clock?
Thank you.
All right.